And I hope to share with you some new information tonight or to clarify some misunderstandings about dispute resolution options and how to apply to those and what makes for a valid complaint and how you can possibly enhance your prevailing rate in the dispute resolutions options with some of the technical assistance I'm going to provide tonight. At the end, there are some questions that were submitted prior to the webinar. I have addressed those in this PowerPoint, but I want to make it very clear to everyone that they look like it applies to you or your specific situation as an individual or something systemic within your school division. Commentary tonight should not be considered as a determination that a school division is out of compliance, or for that matter, in compliance with any special education laws or regulations. The only way that a school division could be found to be in non-compliance or compliance in a distribution option is through a review of totality of the record and the facts involved in each case. So again, some of the information may sound very, you don't take it as, yep, Hank has said that the school division is out of compliance based on anything I'm saying tonight. It's for you to take a look at what the regulations require and use that information on whether and how you want to proceed. So we are here tonight. We're here for about an hour. There's questions at the end, and then we'll take questions on the chat as time permits. So if you want to go to my first slide, that would be great. Okay. First thing I want to make clear to everybody is that even in this COVID situation, the IDA 2004 implementing regulations and the regulations governing special education programs for children with disabilities in Virginia, referred to as the Purple Book, have not been waived, suspended, or modified in any way. There's been no dismissal of any of the requirements associated with the regulations, and everything remains in effect. And thus, as the next slide will show, all of the procedural safeguards are also still in play. Tammy, can you go to the next slide? As I said, the procedural safeguards outlined in the regulations governing special education programs for children with disabilities in Virginia have also not been waived, suspended, or modified. So things related to the provision of prior written notice, things related to parental participation in meetings, anything associated with the regulations is still valid and need to be applied. Next slide.
Okay. And Hank, everyone is having some issues. I think it's glitching a little bit. So maybe if you turned off your video for the presentation, maybe that will help. I'm not sure.
All right.
Okay, we'll try that.
We'll see if that helps. I can control a lot of things. One thing I can't control is internet.
Exactly.
During this discussion tonight, we're going to talk about 5 different dispute resolutions options. The facilitated IEP, which may be a new term for many of you, the filing of a state complaint, the use of due process hearings, and then expedited due process hearings. Next slide. So, what are some qualifying reasons for accessing special education dispute resolution options? Most common are reasons related to a disagreement in the school division over an individual student's evaluation or reevaluation, identification as a student with a disability under one of the 13 categories, restrictive environment placement. But most disputes, even those 3 before, actually tied to the provision of a free appropriate public education. The biggest area of disagreement that I've seen in the 15 years I've been at the department. So we will talk a little bit more about what all those mean and how do we access. Next. Some other reasons are basic procedural violations of the federal and/or state special education laws and regulations related to parental participation in meetings, the provision of parental consent, and issues related to prior written notice. Also, we see there's allegations of disability harassment, allegations of systemic noncompliance within a school division, and I will talk about that in more depth as a presentation. Next slide. Things that cannot be resolved through the dispute resolution options are things that are related to the school division's local policies and procedures. Of course, those policies and procedures are totally contrary to what is required in and/or state special education laws and regulations. Dispute resolution cannot be used to address the professionalism or conduct of teachers or other school division employees. Issues related to the professionalism of teachers and school employees must be addressed at the school division in accordance with any local policy and procedures that the school division has addressing such issues. How's the audio now, just out of curiosity?
It's still glitching back and forth a little bit. It's maybe every fifth word or so kind of goes out.
Somebody just responded terrible. All right, well, we'll muddle through then. Other things that are not appropriate for dispute resolution are a teacher's aide, certified or case manager assignments. Division has the right to determine what staff are assigned to work with what students in what classrooms, and so you can't file a complaint on what teacher your child has or what related service provider they got or their case manager assignment. You can certainly request it, but there's no requirement in special education laws and regulations that require the teacher aide to be a discussion and a requirement to provide a child with a free, appropriate public education. The same would apply to classroom assignments, unless there's a question of the least restrictive environment being the only environment in which a child can receive a free, appropriate public education. And then same with teaching methodology, unless a specific methodology is determined by the IEP team, any methodology that can be used to educate a child, provide information and instruction to progress on their goals. And you can't just file a complaint saying that I don't like the methodology that's being used. You can certainly address that kind of issue through one of the dispute resolutions, and I'll talk about that a little detail as well. And the same would apply to classroom assignments and the brick and mortar school assignment. A lot of parents want to have their child in one building versus another due to be the best location. Maybe it's still in zone or maybe it's out of zone. But the IEP team has said that this specific school, this specific building, the only building where the child can receive a free, appropriate public education, location of school assignment is left to the discretion of the school division in accordance with its policies and procedures related to such assignment. All right, next question. Next slide, excuse me.
Oh, sorry. Here we go. Apologize.
There's other reasons for disputes, and we'll talk about these briefly. Section 504, FOIA, Freedom of Information Act, the violations, and FERPA violations. Discrimination issues would have to be addressed directly through the Office for Civil Rights, and the difference between disability harassment, which is a bit that can be attached to the provision of a free, appropriate public education, disability discrimination. Distinct difference. If you believe your child is being harassed because of their disability, then you can address that through the use of the dispute resolution processes, because disability harassment is a part of the provision of a free, appropriate public education. How would I define harassment? Name calling, picking on the students simply because of their disability. Different in discrimination would be that because of your disability, you can't do A, B, or C. There's a big difference. Hopefully that explains that in clear enough detail. Section 504 is becoming a inquiry for the department, or at least for the people within my office and on my team. Section 504 is a general ed provision, and therefore be addressed through the dispute resolution processes as resolving through a state complaint. That's not to say that mediation and due process couldn't be used, but Section 504 generally would have to be addressed through the Office for Civil Rights. FOIA violations that are strictly allegations related to the Virginia FOIA requirements would have to be addressed through the FOIA Council. Get confused with your right as a parent to be able to access your child's records, getting information from your record. There's a difference between a FOIA and a request made under the provisions of the procedural safeguards outlined in Virginia regulations that talk about the procedural safeguards and the access to records. HIPAA violations, which are issues related to the release of health information, would have to be addressed with the appropriate office. FERPA regulations and violations have to be addressed with the Family Policy and Compliance Office if they're strictly a violation of the FERPA regs, but again, get confused with your rights as a parent to have access to your child's records as outlined and required through both federal and state special education regulations. So it's how you couch the complaint that could be moved forward or to be returned because you're not alleging a violation of state or federal special education laws and regulations. FERPA violations, somebody asked, what is FERPA? It's the Family Educational Rights, Family Educational Rights Protection Act. I think that's right. Yeah, that's an off-the-wall question that I wasn't prepared for. I know what it means, I can't recall exactly, but I'll answer before the end of the night. And then somebody, I think, asked a question about contacts for the FOIA Council. That information by typing Virginia FOIA into a web browser, and it'll take you to the council webpage and talk to you about how to file or how to ask questions or give you contact information to reach out to the FOIA Council. FERPA is the Family Educational Rights and Privacy Act. Somebody just sent that to me, whoever that was, thank you, but I figured out before I saw that, but I do appreciate the help. Next slide, please, Tammy. So I mentioned free, appropriate public education. This is where most of our disputes come from. I'm not gonna go into a deep discussion on, other than to say it needs to be available for children with who related services through the age of 21, in other words, before they turn 22. And that's even if they haven't failed or been retained, been suspended or expelled from school. Next slide. The services provided child under FAPE shall address all child identified special education and related service needs and the placement needed to provide those services, receive a free appropriate public education, must be based on the child's unique needs and not on the child disability category. Example would be a child that is not eligible through criteria and evaluation criteria for an emotional disability is eligible under a learning disability. That doesn't dismiss the fact that the child may exhibit behaviors or have needs that need to be addressed because of some emotional situation going on with the child. A category identified in the child's record or having even been evaluated for, the child has needs that didn't qualify for a category, need to be addressed through the child's IEP. I don't make this stuff up. The regulations that I'm referring to on these slides are stated right there at the bottom with those boxes. Fairly clearly written in the regulations. Next slide. So, if we were all together, I'd ask you the question, what is the most important word in free appropriate public education? You would yell out free, but most of you would probably say appropriate. Correct, appropriate. It is the appropriateness for the child. Each child's IEP needs to address needs that are appropriate for that child, and the provision of FAPE must be individualized. Make this point here that what was FAPE prior to COVID appropriate is certainly going to look different in a situation. And we all need to understand that. Provision of FAPE, the regulations don't change on how you determine it. Appropriateness for each child is going to look a little bit different or quite different in some cases in our current situation. But that doesn't mean you as a parent can't ask for anything that you believe to provide a free and appropriate public education. Next slide. So here are some helpful tips on keys to getting resolution. The first one is early identification. As soon as you believe something is not right, you need to raise that issue through your IEP team or by asking questions of your case manager, BDOE to get some technical assistance. You don't want to wait to raise an issue at the end of the school year as to why your child did not, one, graduate or pass or didn't meet his goals. If you saw an issue going out early, identify it, work to address it so that you get a timely issues, because you don't want to wait too long, continue to struggle. So you want to communicate your concerns, specific incidents, and provide the facts. Introduction piece that the key to resolution in a dispute is what do the facts support? And I will say it this way, he with the most facts is going to prevail in a dispute, whether you're in mediation, whether you're in a state complaint, or whether you're in due process. It's the facts and the documentation that's provided to support those facts. They're going to provide the information to make a determination of whether a school division is in compliance or out of compliance in regards to the issues that you're raising. We also want to stress that you want to try collaboration first. Work with the school division, use the IEP team process, use the chain of command within the school division. What I've got stated here is a chain of responsibility. Parents stop at the school level because they've been told by the principal, well, this is my school, this is the way we do it here, this is how it's going to go. And they realize that they can reach out to the central office folks, starting maybe at the special ed director level, the superintendent level, going to the superintendent level, and even using their local board of education about their issues. So collaborative means are always better. It's the willingness of both the parent and the school division to work together to try and reach a resolution. You want to stay away from negativity and name calling. I don't know how many emails I've seen, documents I've seen in complaints that contain things about how the school is so negative and calling people. That doesn't bode well for the process. It doesn't change anything. It's still the facts. But again, you're being totally negative and calling people names, pointing out flaws and continually pointing to the negativity. You're probably going to run into some resistance. It doesn't mean that the school division still shouldn't be following laws and regulations, but you, what's the old adage? You get more bees with honey. And then I would say, make sure you seek out assistance from other resources. Talk to other parents initially. They may have gone through what you're going through and they may have found a resolution that worked for them and that you could try. And your school division should be able to point you to get assistance. You can certainly reach out to the Virginia Department of Education, to my team members, and that's what we are there for, is to provide technical assistance to both advocates on what the regulations require, judgment on whether a school division is in compliance or out of compliance, because as I said, we would not have all the facts available to us, but in the direction of what regulations may need to be reviewed and considered in a more collaborative fashion and going back to the school. Any questions on any of that? Put in the chat right at the moment. Okay, let's go to the next slide, Tim. All right, let's talk about a facilitated IEP. And if I again was with you, I'd probably ask you to raise your hand. How many of you have heard of this? And more than likely, I would probably get maybe half of you raising your hand. Facilitated IEP is a relatively new process, and exactly what it says. It's facilitated by a third party. Like mediation, it's voluntary. It's requested when discussions and interactions at IEP meetings are creating an unproductive climate. We don't want relationships to start to fray, so we're seeking some assistance. And we've multiple IEP meetings and you're not reaching resolution or completing a quality plan. This gives you an opportunity to resolve issues at the local level. Trained facilitator assessed and keeping the meeting on track with regards to content and process. They do not provide commentary on the discussion. The discussion starts to go awry, they guide you back to on track and focused on the purpose of the meeting and focusing back on the child. And then challenges of communication during an IEP meeting where parties are encountering continuing difficulty with the aid of facilitators. Next slide. So the facilitator is a person who is acceptable to both parties, substantively neutral and impartial, is a well-versed expert in the requirements of the IEP process. And it's my understanding most of the people that are on the facilitated IEP list are ex-special education directors or had some very lengthy involvement with the special education process and understand the IEP process quite well. They're an advocate for the process and not either party. They're neutral. They're going to model effective communication and listening techniques. They're an expert on a process, and as I said earlier, do not offer advice or recommendations. They keep the meeting going. Would a facilitator, no, a facilitator would not be assigned to an LEA in which they previously worked in. They're going to be neutral to the to the process, and one way to remain neutral to the process is to be neutral to. Good question.
And there's a question about, is the facilitator a third party from within the same county?
No, again, I think I just answered that,
Okay,
a facilitator that has no connection or in the past with your school division. Again, we want to keep it neutral. And again, it's got to be acceptable to both parties. So if you apply for a facilitated IEP meeting and the school division does agree, you would be told who the facilitator is going to be. But if that's not acceptable, you can let the facilitated IEP coordinator here at the Department of Education know that you prefer another facilitator be assigned. Okay, next slide. A facilitator is not a decision maker and does not give advice. They are not a mediator. They are not a member of the IEP team, not a consultant or a trainer. They're not a clerical assistant to the IEP team, not responsible for evaluating any of the components. They are there, as I said, to monitor and keep the process and the discussion going. Excuse me. And they're not a judge of what the IEP team does. They're not going to admonish an IEP team member for anything they do. They're going to take anything they see and guide back to the discussion and keep positive track. Next question. Next slide. So, what can you expect them to do then? Your team in establishing an agenda. They're going to make sure everyone has a chance to speak and be heard. A lot of complaints and concerns and questions from parents about get a chance to speak at my meeting, or they don't listen to me. Let other people speak at the IEP meeting. It's just the school representative or potentially the case manager and the themselves are not given an opportunity to speak. This is where the facilitator could say, hey, we need to let everyone have an opportunity to provide their input. And as I said, they help keep the team on task and within the time allotted for the meeting. I know we've talked to many parents that have been to meetings that were scheduled for an hour and went on for longer than that because they couldn't stay on task. And this is a good way to, if you've got meetings that continue to do that, to try and facilitate an IEP established. And then they seek to improve the clarity and understanding in the communication process. So somebody, I think, asked in the chat, request a facilitator. That would be a request through the Virginia Department of Education's Office of Dispute Resolution and Administrative Services. And the coordinator of facilitated IEPs is the same for mediation, and that's Mr. Art Stewart. His email is arthur.stewart@do.virginia.gov. And he would be the one that would facilitate getting the meeting scheduled, getting agreement between you and the school to participate in the facilitated IEP processes. Question, are facilitated IEPs available statewide? I have not been advised that it's only available in any one or two locations. I asked Mr. Stewart to provide me some information to present tonight to make sure I'm thinking of the process, because it's not used that well often. I wanted to make sure I didn't say something that was totally against the process. He did, by the way, it's only available here and there. It was done as a pilot only in 2 divisions, but I believe now that it's being offered to anybody that requests the facilitated IEP process. Best way to find that out, if you're interested, give Art Stewart a call or send him an email and he can tell you where it is available or not. But I would believe now the pilot process is over that it is and should be available across the Commonwealth. Next slide. Thank you, Tammy, for putting that up.
sure thing.
How is facilitation different from mediation? Facilitated IEP actually occurs at a regular IEP meeting, where mediation is a separate meeting run and operated and conducted as an IEP meeting would be. But a facilitated process is exactly that. It is an IEP meeting with a facilitator. There's no written document other than the IEP and prior written notice that would accompany it. Mediation is the format to use when there is a difference of opinion between parents and school, and or a significant disagreement with the parties have been on which the parties have been unable to resolve. That's the difference. So, any more questions on facilitated IEP?
There's one that just popped up that asks, is there an order for asking for mediation versus facilitated IEP?
There is no order in which you have to request any of these dispute resolution processes, but I'm going to provide some Hankism on how the process can best serve you. But I'll state straight up, you can go straight to due process if you wish, or you can go to a state complaint, but facilitated IP mediation, we'll talk about that in a little bit.
Okay.
Next slide. So let's talk about mediation. This is what most people are probably more familiar with. Again, this is voluntary for both parties. It can't be used to deny or delay the right to a due process hearing. It's provided by a qualified, trained, and impartial mediator that is not an employee of VDOE or being paid by VDOE does not make them an employee in this situation. Somebody has to pay them. We identify them, train them, but they are not an employee of the department. They are a contractor, technically, and they are kept on a list, usually done through rotation. They cannot be an employee of a school division that is a party to the dispute, cannot have any personal or professional interest in the case to which they're working on. They are assigned by the VDOE, and mediation is provided at no cost and is scheduled in a timely manner that is convenient to both parties. The school division may have a list of all the mediators, but the list is maintained by the Office of Dispute Resolution and Administrative Services, the official list. And even though you may know somebody that's a mediator by trade, they would not be able to be assigned to do a mediation under the dispute resolution options unless they were on the VDOE list. Next slide. Through mediation, there is a formal agreement developed. The discussions about it are confidential. Discussions cannot be used as evidence in due process hearing or a civil proceeding. And the agreement is signed by both parties. This is different than an IEP meeting, obviously, because an IEP meeting requires a group of people to be together that are defined clearly in the regulations, where mediation doesn't involve that many team members. It's generally the representatives from the school and the parent, and they sit and work and try to work out things formally through a mediated process where the mediator can make suggestions, can remind both of what regulatory requirements are there. This is also a place where agreements that can be made, that can't be made and shouldn't be made during the IEP process, actually reimbursement for transportation if that was an issue, those kind of things. But there's a formal agreement as to what both parties agree to. It is documented, and that agreement is enforceable in state court, court of the US. So it's quite a legal document. The timeline for completion of mediation session is dependent on the scheduling difficulties and the issue or issues being addressed. Mediations be held within a matter of a week, and I've seen it take a little longer as far as trying to get a time, and then time because of the number of issues or the depth of the issues can take a little longer, but it is a relatively short process. And there is no appeal process in the mediation system. Somebody just asked a question about, can you continually repeat to seek mediation? There's nothing that prohibits it. But I have a saying that if you're getting no, that's a request for more information. So if you told no once, ask them why, so you can look at finding a way to remediate that no and turning it into a yes when you ask the next time. The ask is not against the regulations. Again, it's a voluntary process, and if you want to engage, they don't have to tell you why. We do not wish to engage in mediation, and that leaves you with the other dispute resolution options that we're going to discuss in a minute. Next slide, Tammy. Ooh, is 7 months an inordinate amount of time to wait for mediation? I'll answer that question before I start on state complaints. Again, not knowing what the holdup is, I would say that the amount of time is a little lengthy, considering mediation can be scheduled in a matter of days if the parties agree. So I don't know what the holdup is or what the situation is. So I want to go much further than that. But I would say that if you're not getting a response to your request for mediation, that's probably a no on the part of the school division. That this hasn't been properly communicated to you. Have got it scheduled. There may be some underlying issues that are totally unique and probably haven't occurred previously. I know we had one mediator that had gotten ill and his cases got hung up for a while, but again, that's a unique situation. But to just arbitrarily not get a response to mediation for that amount of time, I think would be something that you'd want to address with Art Stewart. In fact, my recommendation, if you don't get a response to your request for mediation within a few days, that I would reach out to Art Stewart and or your school division and ask them, what's the holdup? Are they agreeing not, are they not agreeing to mediation, or is it just the appropriate time? And again, if you've requested mediation during this time of COVID, the time might have been part of that issue. All right, let's talk about state complaints. State complaints must address violations that occurred no more than 1 year prior to VDOE's receipt of the complaint. And the receipt is the date that it appears in somebody's hand or email at the department. And notice it's not more than 1 year. And that's where I tell you again, do not wait to identify issues, especially if you're going to end up going to state complaint. So if you on an issue that occurs now at the beginning of this school year, and you wait too long, you may put yourself outside the 1 year window. I'm not saying you rush to the state complaint process, but keep in mind that you can't address issues in the state complaint process that occurred more than 1 year prior to DOE's receipt. It used to be prior to the new regulations that could be adjusted based on the circumstances, but now it's clear no more than 1 year. A state complaint can be filed by an individual or an organization on behalf of a student or on a systemic issue that they believe is occurring within the school division. So if it's filed by somebody other than the parent, though, consent provided to provide additional information to the filer once the complaint is received. In other words, an advocate can file a complaint on a parent's behalf or a student's behalf without the consent from the parent to continue to provide information. Information that the advocate's going to receive is going to be the notice of complaint. They won't get any information about the follow-up. So if you've got an advocate involved and you want them to be part of your process, make sure you've given the Department of Education the consent for the release of information to your advocate. Complaints cannot be submitted anonymously. And then if there's any portion of a complaint that's in due process, that must be placed in abeyance, which is a legal term for putting it aside until the due process hearing results are rendered. How can you get an advocate? We maintain a short list at the department that has some advocate organizations, but in fact, that the best way for you to find an advocate is to reach out to the parents within your division and we don't keep a list at the department of the advocates and attorney groups that are doing advocacy work on behalf of parents of students with disabilities. All right, next slide.
Sorry, it wants to stick. There we go. And there's been a couple of questions about the PowerPoint. For those of you who are here tonight, we will be sending you a PDF of the PowerPoint, and we are recording it, and we'll see how the sound comes out in order to be able to put that out as well.
All right. If there were any issues in a due process hearing, they cannot be raised through the state complaint process. If you disagree with those findings, because due process findings on an issue are binding and final. Now we'll talk about due process, appealing due process hearings and so on later. You can file a complaint for an alleged failure to implement a due process hearing, but you can't file a complaint on the results of the hearing. Does that make sense? And the thing to keep in mind with a state complaint, there is a 60 calendar day resolution process, which means 60 days, calendar days from the date receives it. They need to issue a letter of findings or a letter of inquiry on the issues that were presented in the complaint. But there are provisions in the regulations that allow that timeline to be extended for exceptional circumstances. And I'm not going to get into a discussion on what may constitute exceptional circumstances, because again, everything in special education, to include the dispute resolution, are specific. And you can file an appeal of a finding in a state complaint to an independent complaint reviewer as in the school division if you believe there was an error in fact in rendering the findings or produced documentation that was not reasonably available at the time of the complaint was filed that supports your position and may render the findings to be returned or reversed or otherwise modified based on that new information. Next slide. Okay, due process hearings. A parent or a school division may, in writing, file a due process complaint regarding matters associated with the identification, evaluation, educational placement, or the provision of FAPE. Due process, you have up to 2 years to file your due process hearing request. 2 days before the date that the parent or school division should have known the action forming the basis for the complaint. In other words, when you knew it, you have 2 years from that date to file. And this again goes back to don't be waiting. Move into the dispute resolution process or into the collaboration process as soon as you identify an issue. Copy of the due process hearing request must be provided to the other party at the time of filing with the VDOE. So in other words, as a parent, if you're going to file a due process request, you need to make sure that you send a copy to the school division and to the Virginia Department of Education's Office of Dispute Resolution and Administrative Service. Okay. Actually, it can go to anybody in the department, but I advise that if you know you're going to file a complaint, seek due process, you might as well just send it straight to ODRAS because that's where it's going to end up. People complain to me all the time, and I just sit forward to the Office of Dispute Resolution so that they get it the same day that I get it to trigger the timeline. Okay. And so do the other members of my team. They've been taught to file any request for complaint or due process to immediately forward them to the attention of the director. Okay. The school division must inform you, the parent, of the availability of mediation in any cost legal or other relevant services available. And this would also be something that you could ask the school division for when the person asks a question about where can we get a list of advocates. These would not technically be advocates. They're probably going to be more attorney groups, but at least be a starting point for you. And they need to provide that to you when you request due process, which means they probably have a list available. So you can reach out and ask them if you're looking to, assistance from somewhat other division, if they would make that list available to you at that point as well. Next slide. And then the school division must also provide you a copy of the procedural safeguards upon receipt of the first due process hearing within the school year. The filing must be kept confidential by the school division and the DOE. In other words, we're not going to put the information out to the public that we've got a due process regarding a situation in X county or anything like that. And then the party filing must forward a copy to VDOE. I said that earlier, but I reemphasize that. Don't just send it to the school division. Make sure you're sending a copy to the school. Next question, or next slide. Now, somebody asked about mediation due process. Upon 15 days receiving a notice of the parent's due process and prior to initiation of the actual hearing, the school division shall convene a meeting with the parent and relevant members of the IEP team to discuss potential resolution. That meeting could be a mediation, but not necessarily, doesn't have to be. It can just you and representatives of the school sitting down and coming up with a resolution. Going to include a representative LEA that has decision-making authority. And this resolution session cannot include the attorney of the school division unless you bring yours. In order to file a due process complaint, could I, the parent, just send a letter of request? You could, but your letter would have to contain all the components outlined in the due process regulations. In other words, having all the required information. And the same would apply to the state complaint process. And those forms are available on the VDOE website under special education and dispute resolution. You'll get more detailed information about all these processes and the forms that are templates but not required to be used, but all the information needs to be provided no matter what method you use. Complaints can be filed by email. Requests for due process could be filed by email. Mediation can certainly be filed by email, but there's got to be documentation included in all of those requests. Next slide. Now, the resolution session doesn't need to be held if the parent and the LEA, the school division, agree in writing to waive it. The parent and the local education review use the mediation process, as I mentioned earlier. And the school division is a party requests a due process hearing. They do not need to hold an early resolution session. And then you and the school division determine what relevant members of the IEP team to attend that session, if in fact you're just doing it as an early resolution. Remember, as I said, if you go to mediation, it is not the same as an IEP team meeting. The same members, but it's not required. Next slide. A decision by the special education hearing officer in a hearing is final and binding unless it's appealed by the party and by either party in a circuit court within 180 days of the issuance of the decision, or court within 90 days. And as I said earlier, if the hearing officer decision is not implemented, a complaint may be filed with the Virginia Department of Education investigation in accordance with our state complaint resolution process. Next slide. All right, expedited due process. This sometimes gets confused. expedited due process attaches to requirements to do an expedited due process attaches only when the parent of a child with a disability disagrees with the manifestation determination decision where it was found that the child's behavior was not a manifestation of the disability. The school division is making a change in placement because of the violation of the student code of conduct, or that the school division believes that maintaining the current placement of the child is substantially likely to result in injury to the child or others. That's when an expedited due process requirements kick in. Parents have been known and advocates have been known to ask for an expedited due process on an issue that doesn't relate to a manifestation determination decision. That would not be applicable. There's no requirement to do it in an expedited manner, only for issues related to behavior. All right, next slide. All right. In preparing for filing for a mediation, filing for state complaint, filing for a due process hearing, and even in requesting a facilitated IEP, although again, the facilitated IEP really isn't a dispute resolution option. It's a method by which you can try to work through a situation with the IEP team and the communication process and just being able to move forward. But if you're going to ask for mediation, a state complaint, or a process, these are some things that I highly recommended that you be prepared to do. You only need to make a statement of a violation. And the statement does not need to identify the actual regulations. In other words, you don't need to state that the school division has failed to provide me with the prior written notice as required under the regulations at 8 VAC 20-81-70. All you have to say is the school division has failed to provide me with a prior written notice prior to seeking my consent for the change in educational placement recommended by the IEP team September 2nd, 2020. Statement of the violation and the facts. When did it occur? Who was involved if you know it? Whatever facts you can provide. And then you want to provide any type of documentation that you believe supports your allegation. And the documentation you can provide can be anything. If you're not already doing so, I highly recommend that you're keeping phone records of every conversation you have with anyone regarding your child's access to a free, appropriate public education. That could be a piece of information, that could be the fact and documentation of the fact that puts your complaint in a better position to support that the school division is out of compliance. There's nothing that prohibits you from entering as evidence of your violation a written note of a phone conversation or a personal face-to-face conversation that you had with a member of the school division staff regarding your child's provision of FAPE that occurred maybe at a parent-teacher meeting, passing the hallway, meeting at the snack bar at a basketball game, and you had a conversation and they said something to you that might attach to your child's provision of FAPE or an upcoming meeting. Document that, keep it in your records just in case you may need it for future reference. Keeping any emails or any other correspondence that you receive from the school division and or any letters or any information you provide to the school division. Okay. Also, you want to state what would you accept as a resolution to this issue. And I say it this way, you can shoot for the moon, but be realistic. All you want is your child to be able to attend certain location, state that. And if the school division can solve your complaint by giving you that resolution, then you don't have to go through and wait on the processes. Make sure you maintain a copy of anything that you send with a complaint. I don't care how much you send, you want to make sure you've got a copy of it somewhere. I'm not saying print off all the emails that you sent as an attachment to your complaint, but if you've got a record of them somewhere, that's all you need. But if you've got other documents you're maintaining in a separate file that you're sending, maintain them. Don't send the original and forget to make a copy. I have seen that in complaints I've worked. Parents have sent the originals of documents, and I'm wondering if they kept their own copy. In fact, I would suggest sending only copies. There's nothing that requires you to send originals of. And then somebody asked, what order should I go through? Use the process you're most comfortable with and in a logical order. If you are failing to be able to resolve an issue through collaborative methods and it's because the IEP team is just not able to stay focused, then you might want to request a facilitated IEP meeting first. If you believe that would be not your best interest or the best interest of the child, then you certainly could mediation or directly to a state complaint or seek a due process hearing. I didn't mention this when I was talking about each individual process because I wanted to say it here. The prevailing rate in mediation is about 82–83% that you're going to come away with an agreement that you and the school division can agree upon. In other words, be able to resolve your issue through the mediation process. In a state complaint, it's about a 50-50. About half of the complaints we receive are founded and the other half are unfounded. That doesn't mean incompleteness. Sometimes a parent will file a complaint on several issues and most of the issues are in compliance, but there may be one or two that are out of compliance. And that process takes 60 days. And again, remember I said mediation can be relatively short. Due process hearing, prevailing rate, if you don't resolve it in the early resolution session, is very low. And the thing you need to remember about a due process hearing is that it is a litigious process. The school division is going to bring their attorneys. Not that you as a parent cannot represent yourself in the process, but if you are not well versed in the process and aren't familiar with how to question a witness and to present evidence, then your opportunity for prevailing is probably going to go down. But I have known of at least one case where a parent has prevailed on their own in due process, so it can be done. So that brings up the problem, not the problem, but the issue that going into due process, you're probably going to need an attorney. And attorneys don't do things for free most of the time. They do some pro bono work, but most of them are going to have a fee for their services. And those services can be, somewhat daunting for a parent. Even if you've got the funds for it, it's going to drain your resources. And the other thing about a due process is it is a lengthy process in some cases. Sometimes they do resolve the issues. Other times they continue and drag out. You still don't come out with a resolution to your benefit. So those are some recommendations from me. Those aren't stated in any regulations. Those are what I refer to as Hankisms, things that I've learned over time. Like I said, I've got 15 years in DOE, and I've learned a few things along the way in talking and working with parents, advocates, and school divisions. And these are things that I use as a complaint specialist to help parents process complaints worked through without having to return them for correction or return them for insufficiency or whatever. The cleaner your complaint is going in, the faster that process is going to move. Next slide. All right, let's take a look at the chat box because I see a lot of people thinking I'm ignoring questions, I guess. Really like to know if the regulation violations have to be for a certain law area. Any complaint needs to be a violation, alleged violation of state or federal special education laws and regulations. In other words, the IDA 2004 implementing regulations or the governing special education programs for children in Virginia, the regulations, or as I lovingly refer to it as the Purple Book. Tammy, did you see any other questions that
Yeah,
were?
there's a couple. There's a question about the list that's on the website, the VDOE website, asking if that's going to be updated at any point.
Yes, that is something that my team is actually working on as we speak. And I don't mean they're working on it right now, but it's on their radar to be. And we're going to go to ODRAS and say, hey, you know, we've seen it and we've gotten comments from parents and advocates that the list is not accurate or needs to be updated. So yes, that
Okay.
will be.
And then a follow-up to that was what happens if that's the only list they get from the school? Is there another place they can get a more updated version?
Not until it's updated by the department would we have any, not until we have it posted would we be able to provide anything new. And again, my team and I, and even people in ODRAS cannot recommend a specific advocate or attorney group to a parent. We can only try to provide you resources on. I'll be totally honest, we refer a lot of that to Peachy to see what resources.
Right. Right.
And then also we do use the Center for Family Involvement over at Virginia Commonwealth University. They've got resources that sometimes that are not available directly to us, or because of their work with parents or their work with their own children, they know of advocates and attorneys that are now working within regions across the Commonwealth, because VCU does have navigators, as they call them, throughout the Commonwealth. So they probably have some resources available to provide to parents.
Right. There's a lot of questions coming through right now. Some are specific individual situations and some are more general. So I'm not sure how much, if you want to address those now or if you want to address those afterwards, individually.
What I'm going to do is defer anything that's individual to a discussion. And I'll talk to at the end on how we're going to do that.
Okay.
Again,
and I'm trying to dig through them. So I apologize if I'm missing your question that's general.
Yeah. But again, I don't want to discuss a student-specific issue or even a school-specific issue because again, everything is relying upon facts, even providing technical assistance. What I would say to one parent might be different with another parent based on the facts as the parent presents it. So I wouldn't want to be misleading to the group by addressing a specific issue with one parent in this venue.
Okay.
Yeah, there's questions like, can it be blamed on COVID? I'd want to know more information before
Right.
I provide, a realistic and responsible answer to that question.
Right. So we, for everybody who's here, we do have your information that you use to sign in. And so we can follow up with some of these questions and we'll follow up with some of these questions very specific to reach out to you to make sure we give those. I do see one,
What
I think.
I'm going to do is I'm going to ask Tammy to print off all of the questions in the chat and send them to me. And I will do as I did with the previous presentation and respond to them individually unless somebody provides their contact information, or better yet, if they just want to send me an email after this presentation, either this evening or tomorrow or in the next day or so, with their specific questions, then that might be the best way for me to address a student-specific issue.
Okay, yeah, I think so.
And
As I'm looking through, I think most of these are very, you're going to want to, the people asking are going to want an individual, it's gonna be an individual information and questions because you'll need to get more information. But I did see one that said, can the school division, I'm trying to find it again, but can the school division bring an attorney to an IEP meeting if the parent is not?
Yes,
Okay.
the parent has, or the school division, as well as the parent, have a right to bring anybody to an IEP meeting they believe has knowledge or special expertise related to the student.
Okay.
I'll just leave that answer at that. If that parent wants to talk to me more in depth, I would be glad to do that.
Okay, sounds good.
Yeah, and somebody said I should have a slide for Hankisms. Yeah, that'd probably be wise. Good way to get myself in trouble, right? No, there's nothing I'm going to say tonight that I won't stand up and say to anybody else. So take this information as being what regulations are saying. And when I say it's a Hankism, that's just saying this is something that's not covered in regs. It's suggested stuff. It's not like I'm trying to make up a regulation. It's just providing you all with some general thoughts and practices that I know have worked over the years and my working with parents and advocates in school divisions. So,
Okay.
all right, let's go on to the next slide because this is where I'm going to get actually into some of the questions that were presented earlier.
Yeah, and I think this will help answer some questions that we're seeing, and then again,
Probably.
we'll follow up on these specific ones.
Right.
Okay.
All right. How can parents break the loop of being referred back to the school division to continue to work out their issues? And I know that my team is guilty sometimes of telling parents that probably need to go back, but that's because normally it's because in talking with you, you really haven't used the chain of responsibility that I stated. And I had somebody, I do remember seeing that question pop up in the chat. Where can I find the school division's chain of responsibility? Go to their website and you'll be able to see, what the levels are. Basically, it's you got the building level, which would be the IEP team and your case manager and the school administrator, and maybe in some of the larger school divisions, a coordinator for the area. But then you've also, every school division, regardless of their size, has somebody at the central office that is responsible for the administration and compliance with the federal regulations. And that is generally someone that's identified as either the director, the supervisor of student services, lots of different titles. And the way you find that out is to ask your case manager, who at the central office can I go to? And if you're not getting a response there, you can certainly reach out to my team, and or you can access the site on the DOE website and go to the listing by division that we maintain, go through that and find the person you may want to talk to. But to be honest, the quicker way to do that with a large division would be to call my team, because we pretty much know who the point of contacts are, navigate that part of the website a little quicker than most parents will if it's the first time they've accessed it. But the other answer to that would be, because I think this may have applied to parents that have filed a complaint that comes back as being insufficient or whatever, or being advised to go back to the school, is the more facts you present, as I said before, the clearer it is to whoever's reviewing your complaint, whether it's a request for mediation, the filing of a state complaint, or requesting due process, the less questions that they need to ask, less information they need to get from you back to the school division to get that other information. So I hope that answered the question for whoever that question, and for anybody else that was having that same situation. Breaking the loop is just getting more information into the hands of the people that are asking for it. As I said before, I've got that old adage of, to me, an answer of no is just request for more information, and we'll do whatever we got to do to get that information and turn the no into a yes. Slide. Is there a guide to help parents decide at what point you need to move past the personal level they have been working with to resolve their concerns? No, there is not a guide. It's wherever you feel comfortable and whenever you feel you've exhausted all efforts to be collaborative and you just are not getting anywhere and getting an answer, you got to make the tough decision to take the next step, which may be to file a state complaint or submit a due process. And again, there is no right way that you've got to climb or steps you got to take to access any one of those. You can certainly reach out to my office, to myself, and to my team members, and we can help discuss your situation and provide some advice on regulations maybe in play and which might be able to better address your concerns. I mean, if it's a disagreement over the provision of FAPE, what the school division is proposing to offer for FAPE, you're probably not going to get resolution in a state complaint, but you may get resolution through mediation process, because state complaints are more about the procedural issues, although you have to look at the overarching issue of whether or not that procedural issue impacted on the provision of FAPE. But if it was done procedurally correct and it's just a disagreement, the parent and the school division IEP team constitutes FAPE, then yeah, mediation or due process would be the best. So everything is individual, and as I said earlier, for special needs, everything is student specific. So reach out, get some advice, get some technical assistance, and what my office was actually created for, to provide more people to be able to address concerns that the department was getting related to parental needs of better understanding these regulations. Next slide. I love this question. At what point should legal representation be present in a dispute process? Whenever you feel you need someone that has got more knowledge and expertise about the process is when you should consider involving legal representation, whether it's a lay advocate or whether it's a full-fledged attorney. That is a choice you've got to make, and there's really no right or wrong answer. I will state that the Office of Special Education Programs has commented there really is no place for attorneys in IEP meetings, because that does make it more of a legal situation than a collaborative situation. They're not saying that they shouldn't be there, can't be there. It's just their comment, not mine, that, you know, bringing an attorney to an IEP process probably isn't going to speed the process along, because it becomes a legal discussion between the school division rep and your rep. It doesn't really, attorneys can't resolve issues. Please don't take that the wrong way. I'm just sharing that getting them involved, you got to decide what to bring them in, and is it going to be to your advantage and to the advantage of your child. Next slide.
And there was a quick question about that. It says, can the school division be responsible for attorney fees?
Potentially in a due process hearing, yes, but not generally in mediation, or you're using the attorney to help you file your complaint. And when I say attorney, I'm also saying maybe your lay advocates that are out there that aren't attorneys, that are acting and helping parents as well. Their fees are not recoupable through mediation or state complaint. And I'm not sure that a lay advocate's fees could be recouped through the due process, because the regulations speak to attorney fees. So unless your advocate is an attorney, you may not be able to get attorney fees if you prevail in the due process. The comment that I made about attorneys in IEP was from the Office of Special Education Programs. That's the feds.
Mhm.
Next slide. Recovery services. I did like this question because this is something new at the department. Recovery services, like whatever the IEP team determines to be appropriate for the child based on the fact that during the school closure, the child has regressed and needs some additional services. IEP team decision. And keeping in mind that recovery services probably don't need to be and shouldn't be discussed until you see how this child does upon returning to school, whether it's through a virtual means or an in-person or some kind of blended instructional model. Next slide. How do the dispute resolutions align with those of the U.S. Department of Education? They run parallel. Our regulations are almost verbatim as to the use of the processes. Certainly the VDOE has established their own complaint process on how we're going to implement those regulations, and those are clearly available again on the VDOE website. And yes, parents end up investing a lot more time, money, and stress when they enter into formal dispute resolution mechanisms. Processes themselves are the same as outlined in IDEA implementing regulations. Next slide. An issue related to the provision of FAPE as being, a child being pulled out of class for support versus a parent wanting the child to receive the services within the classroom. That is a matter of FAPE and will be able to be resolved either through mediation, through a due process hearing, and the decision on the pullout have to be evaluated by the IEP team initially, so the parent could initially start with asking for a new IEP meeting to talk about whether the pullout is working or whether in-classroom supports would be better serving the child, and then a disagreement, then to seek out mediation or due process to address that dispute. Next slide. How can a school system accommodate my child's need when they claim they don't have adequately trained staff? The school division is obligated to provide the services of a child's IEP as it is written. If they don't have the qualified staff to do that, then they've got to find another means by which to provide that service. Some of them do provide, for contracted services for things like speech, PT, or whatever. Or if they can't serve the child in a specific setting because they don't have appropriate staff to fit that accommodation, that's where recommendations for potentially placement in alternative private placements may be appropriate to be discussed by the IEP team as well. Again, if your IEP is not being implemented, it could be a procedural allegation that can be raised through the state complaint process and due process. Again, everything can be addressed through any of these processes, but procedural issues are best and more readily addressed through the state complaint process. And if the school division is found to be out of compliance from a procedural standpoint, then there has to be a discussion of what was the impact that that procedural violation had on the provision of a free, appropriate public education, and whether or not, if any, compensatory services are due to the child. Next slide. I think I answered this before, but again, school does not have to agree to go to mediation, and there's no regulatory requirement that they give a reason for the refusal. Certainly should ask why they're not willing to go to mediation. If it's something that you can find an answer to and come back and request mediation on a second go around, you certainly have the right to do so. Next slide. How do parents address their inability to successfully perform distance learning and their requests for in-person? Again, this is an IEP team discussion, keeping in mind that in-person and distance learning are methodologies, not placements. But if the methodology that is being offered to your child does not seem to be working, then you certainly have the right to request methodology be reviewed and considered for a change to the alternative. And if there's a disagreement on that provision of the instruction, then you have a right to seek resolution through the use of mediation or the due process hearing. Next slide. We are now at the end, I think, which means that we'll take
There's
a
a
quick
couple, you want me to
look.
move on to the next few slides first?
Is there slides beyond that? I can't remember.
There is, there's this one, and then your contact slide.
Yeah, let's stay with the questions first.
Okay,
Any questions in the chat that I can answer? The last one here. If an LEA is found to be out of compliance, as I just talked about, Comp Ed, but they do not comply with the provision of the compensatory services, then that would be a procedural violation related to the provision of FAPE that could be raised that that the comp services have not been provided as a procedural issue for basically IEP implementation, and it can be addressed again through the state complaint process or through mediation or even a due process hearing. Whose comment? Oh, I already has OSEP, Office of Special Education Programs. Was
yeah.
attorneys at IEP meeting. Can the school talk about that? Talk about Rotary.
Yeah, I think most of the other ones I think are very individual that I think will be best to follow up on. Unless somebody has a note that we may have missed, just put it back in there real quick and we'll see it.
All right, so go to the next slide. I can't emphasize this enough. Document, document, document. That's the final Hankism I'm going to give you tonight. Document, 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 document. Everything and anything that impacts on the provision of a free, appropriate public education for your child. Whether it's related to the evaluation, identification, placement, or the overall provision of FAPE. Document that information. I would print this off and put it near your records or wherever. Put it by the phone, do something with it, but document. Next slide. This is my contact information. I even include my office phone number because everybody calls me on the cell anyway, and I'm not at the office anymore because we're all teleworking. So please use the cell number, reach out to me. If you have individual questions that you want answered from tonight's presentation, or you've got other questions that you want to ask, you can shoot me an email and I will ensure that someone from my team responds. It may be me, but I have two other very competent individuals that work in my office, Tracy Lee and Gloria Dalton, that can certainly provide the same level of technical assistance that I do. So we will get you an answer to your question, and send it to me in email format. You're going to more than likely get an email response. And after that, if you want to talk about it in an individual fashion, more in depth, you can then call me as well. If you call me on the phone, I'm going to call you on the phone back. Or again, have somebody else call you. And that can be a question on anything related to regulation. Doesn't have to be related strictly to this presentation. To provide guidance and assistance to parents on anything covered in the federal and or state special education laws and regulations. But don't be afraid to use the number and the email. Can you appeal a state complaint after the independent review? No, the independent review finding is considered final. Now, that's not to say you can't take the issue in a complaint to due process. can't bring the issue in a due process back to state complaint. Take a state complaint issue to due process.
And there was one question right above that about
Yeah, I
the,
see that.
okay.
Does the district have to honor the standing IEP if an addendum to the IEP, including new COVID regulations, is disputed? It's gone to mediation. I'm not sure what we mean by new COVID regulations. So whoever, if you would send me an email or call me, we can talk about that specific question one-on-one, because there's a little bit more information I'd want to know before I render the comment. Anything else out there, Tammy? I know we're running a little
I think
late.
one last one just popped up about individual complaint versus systemic complaint, and can they do both at the same time?
Yes, and I hesitated for a minute because I wanted to say, if the individual complaint is part of the systemic complaint, certainly, because you're going to have to start off with and provide information on what students are impacted by the systemic issue. And at minimum, you're going to have your individual student that's impacted, and making a broad statement that you believe on every student is a little broad. You're going to have to provide additional information about how and why you believe it is systemic in nature. Certainly, you can start off with it being an individual complaint, follow on and making it into a systemic issue if you've got the documentation to support a systemic issue, or at least an allegation of a systemic issue. A joint due process complaint. Pamela, if you'd send me that question, I will get an answer to you. I don't have an answer to that question. I've never heard that term before, joint due process.
Very good. All right, again, everybody, we will capture this chat and we'll send it out to Hank to have, but also, as he said, if you have a question, you have his contact information showing here, and you can directly send that to him or give him a call, and he would have that immediately as well. Anything else, Hank?
No, I think that's it. Again, I appreciate everybody's time. I know we went a little over, but I think the information and the questions were good.
All right.
I'm available to continue to ask questions going forward. So.
Sounds good. So again, if you were on here tonight, I will be emailing you tomorrow a PDF copy of the information so that you can have that. And we appreciate you guys signing in with us tonight, and I hope you have a good evening and a good rest of the week.
Thank you, Tammy.
Thank you. You have a good week.
You too.